Welcome, everybody, to another year of Conn Maciel Carey's annual OSHA webinar series, the 2023 OSHA webinar series that we kick off today with what has become a nice tradition over the years, a look back at the prior year, so a 2022 year in review at OSHA, and a 2023 forecast. And as our team has grown, it used to be that our whole practice would participate in this event, and we've grown so much over the years that now we're doing this with almost all of the partners in the practice. We've got our the head of our Cal OSHA practice. Andrew is not joining us today because we've got a webinar next month focused just on Cal OSHA, and our partner Nick Scala, who heads our mine safety practice, is not joining us because we have a whole separate MSHA webinar series. But otherwise, all of the partners in the practice got together today without any help from our associates. And so you can be assured that this is a sloppy, poorly put together program, and it'll get better over the course of the year when our associates get back involved. But we're delighted to do this series again. It's one of the favorite things that we do every year. We joke all the time that we're big OSHA nerds, and to get a chance to spend a little bit of time every month with you all talking about things that have caught our interest about OSHA, questions that we get a lot, topics that we know are important to many of you, hopefully to all of you over the course of the year. We've got something that is relevant to your industry or something that you're experiencing and dealing with in person. So we're delighted to dig in and get started with another year of the webinar series and with our kickoff event. We're going to cover today a few things. We were this close to not including a COVID-19 topic at all. That's where we think we are and where OSHA is. But we thought it made sense to at least provide a little bit of that context. What is going on the COVID-19 front at OSHA? And then we'll do our usual OSHA enforcement updates, what we saw in 2022, what we think is going to happen, what we think OSHA is going to prioritize, and some new initiatives and practices on the enforcement front in 2023. We will get into OSHA's rulemaking priorities with a little bit of update about what's been going on the rulemaking front over the course of the last couple of years, and a look ahead to what we think OSHA is going to try to accomplish on the rulemaking front over the balance of this presidential term. And then lastly, there's a lot of activity going on with OSHA's Whistleblower division, and Lindsay's going to give us an update about that and what you all need to be aware of on that front. So I'm going to get us started and talk a little bit about COVID-19. And it is just a little bit, I promise. The biggest news in 2022 on the COVID-19 front was the Supreme Court's decision in the legal challenges to the vaccinate or test emergency temporary standard. And that was barely into 2022, but that was what we thought we would be spending a great deal of the year working on, is implementing this very complicated and onerous vaccination or COVID testing rule. But the Supreme Court essentially struck it down in the first month of the year before it went into effect in any meaningful way. In a 6-3 decision, what the Supreme Court did was actually stay implementation of the rule while the merits challenge of the rule proceeded down at the U.S. Court of Appeals level. But they signaled pretty clearly that if the rule came back to the Supreme Court on a merits review, that they would strike it down as beyond OSHA's authority. So rather than subject the rule to that and perhaps create some bad precedent for its own rulemaking authority, OSHA withdrew the rule, and it seemed to really knock the agency on its heels. In the day after the Supreme Court issued that decision, the Secretary of Labor put out a statement that made it sound like OSHA was going to remain very aggressive in holding employers and businesses accountable and use all of the tools in the tool chest to enforce COVID-19 requirements in workplaces. But the decision clearly had a big effect on OSHA. And part of the takeaway from the decision was COVID-19 is not a uniquely workplace hazard, except in a few special workplaces like in healthcare. So OSHA should not be meddling in this. This is a public health issue, not a workplace issue. And as a result of that, and perhaps, just some political motivation or just some exhaustion, OSHA has basically turned the page on the pandemic, except in the healthcare space. So it was an interesting year in 2022 and a good forecast for what we can expect from OSHA. Even as COVID is still out there, it's still with us. It is not much of an issue for OSHA unless you're in healthcare. If you're in healthcare, you know that the COVID-19 National Emphasis Program still exists, but it's been amended a couple of times to focus just on healthcare. If you're in the healthcare space in a hospital or a nursing care facility, you almost certainly had some contact with OSHA during 2022 because they engaged in what they called the COVID-19 Healthcare Enforcement Blitz, in which I think OSHA got into almost every hospital system in the country to evaluate COVID-19 protocols. And then the last thing OSHA's been doing, while they've abandoned all other rulemaking related to COVID-19, they're not trying to do anything in general industry involving vaccination, testing, masks, protocols, any of that, where we had seen some rulemaking in that space up until the Supreme Court decision. OSHA is now focused only on 2 rules relevant to COVID generally, and both of them are focused exclusively in the healthcare space. There is work on the permanent COVID-19 rule for healthcare and a generic infectious disease, an airborne infectious disease rule, also focused only on the healthcare space. And we'll talk a little bit about that in a second. But in the context of general industry or construction, just non-healthcare workplaces, it is like OSHA has closed up shop there. We have not seen any enforcement outside of the healthcare space in about a year. And we were seeing, those periodic, you'd see a general duty clause citation or citations involving OSHA's PPE standards or record keeping standards. And we're still seeing those kinds of actions, but only involving hospitals, long-term care facilities, nursing care facilities, and in that healthcare context. We're just not seeing much of anything at all outside of that space. And that includes not only enforcement, but on the guidance front. It has now been probably about 2 years since the last time OSHA put out COVID-19 guidance. It predated the Delta variant, and that was like, an entire Greek alphabet ago in terms of variants that we're seeing and dealing with in the country. And that guidance is badly outdated. I don't think OSHA could do anything with that in an enforcement context because it is left behind the CDC's guidance and is generally not applicable. So we're just not seeing much from OSHA at all on that front. I'm sure that's a relief to many. If you are in the healthcare space, there is a rule that we have, you can see at the bottom of the slide, that we are expecting literally any day now. It is, if you recall, OSHA issued an emergency temporary standard. They were working on a temporary standard to apply to every workplace in the country. And at the time, this was pre-Delta, when COVID, it looked like it was disappearing for the first time. OSHA pivoted and said, we're going to do a rule, but instead of applying to everybody, it's just going to apply in the healthcare space. That was the healthcare COVID-19 emergency standard. That rule lasted for about 6 months and was withdrawn. But that rule, under the OSHA Act, an emergency standard, serves as a basis for a proposed rule for a permanent rulemaking. And OSHA, it wasn't really taking any steps towards that, but they were sued by big national unions, the nursing unions in particular, to require OSHA to follow through with that rulemaking. A judge has not ruled that OSHA must do that, but OSHA responded to those lawsuits and picked up the mantle and carried on with its rulemaking for a permanent COVID rule. It seemed like that rule might die on the vine because of the last time that we thought, well, now COVID is over. It's not over, but it is certainly not on OSHA's radar anymore. So it seemed, but then in early December, as cases were spiking again, I think OSHA timed this somewhat strategically to not look sort of silly for promulgating a rule on an issue that had seemed to die down more or less around the country. Well, now there's a big spike in cases, so OSHA is looking to finalize this rule. They delivered a proposed final rule to OMB in December. They have been engaged in the OMB review process. And our firm, on behalf of a coalition of employers and trade groups that we organized, has participated in multiple meetings with OMB's OIRA office. And it sounds like, those meetings are dying down. We're seeing an occasional new meeting scheduled here and there, but it looked like OSHA was about ready, or OMB was about ready to clear the rule, and OSHA was ready to finalize it. Typically, they do this on a Friday because they know this is not going to be terribly popular. I thought it was going to be the Friday before MLK holiday weekend. It didn't happen then. I think at this point, we're on that any day now watch. If you're affected by this rule, don't hesitate to reach out to us and we can talk about it in detail. But that was all we wanted to say about COVID-19 this year. We're hopeful that if you're outside of the healthcare space, that this is just a thing of the past in terms of the OSHA landscape. And that freed up OSHA to focus its attention on other priorities. And Aaron Gelb is going to take over and talk to us a little bit about those other enforcement priorities.
Thanks, Eric. And I'm actually in the middle of an inspection, taking a break to join you all for a little bit. It's been a long inspection, so I've got time in between interviews, and I did want to just pop in to address the enforcement slides. I did want to cover, I saw a comment that came in while Eric was talking about record keeping during COVID, and I think Lindsay, I don't know if Lindsay's going to talk about this, but that OSHA is still expecting folks to be recording work-related COVID cases on their logs. I can tell you, though, from all the inspections that I've been managing since over the last 6 months, I've in the logs that I've turned over, I don't recall seeing very many COVID cases on logs anymore, and no compliance officers are commenting or asking about that. Not saying not to record them, I'm just saying it continues to not be a focus. And the inspection that I'm working on right now, the compliance officer is the same one that I had an inspection with about 8-9 months ago, and I can recall very clearly in that inspection everybody was wearing masks. Still, this was probably like April of 2022. There were still partitions in the conference room, and in this current inspection, we're in a conference room in a different company. No one's wearing a mask. There have been none of those JHA type COVID questions that OSHA used to ask at the start of the inspection. And so this inspection and every other inspection that I've been doing in the last 3 to 4 months. Again, your results may vary in your different locales, but here in Chicago, where I'm based, OSHA, as Erica said, seems to have moved on. But as Eric also said, where they have moved on to is back to regular inspections. And as you can see from this graph here, inspections are pretty much right back at pre-pandemic levels, right at the same, almost exactly the same number that we saw in the last year of the Obama-Biden administration. So obviously, we all know why we saw the big dip down in 2020 when OSHA was barely doing inspections in general industry. And if they were, I did inspections that were remote inspections, by Zoom inspections, where safety people were walking around with FaceTime so OSHA could see equipment because they weren't going into factories, right? And then we remember in 2021, they started kind of slowly in different parts of the country, different regions, depending on where case rates were, slowly getting back in. 2022 was pretty much as close to normal as these numbers indicate. And I would bet a lot of money that the bar graph for 2023 is going to go up past last year, and probably closer to the numbers that you see, I would think, in the mid 2010s, that 2013-14 numbers, because they're out there, and you may hear others talk about this today. OSHA is using all the tools in its toolbox, and there are lots of different types of inspections that they can open in addition to accident and incident responses. I'm seeing more complaint inspections, in-person complaint inspections. They're still issuing the rapid response investigation requests, but I'm seeing more opportunities where they get a complaint about certain hazards and they come out and inspect it in person. I'm seeing a lot more follow-up inspections where they're coming back a year and a half after the last citation, even though it was abated, they're coming back to do follow-up inspections. But moving on to the next slide, if you follow our blog or Eric's Twitter feed, you know that OSHA just increased its penalties yet again, as they do every January now. It's kind of it's not a rite of spring. I guess it's a rite of winter, a post-holiday present for everybody. So now we're over 15,600 for serious citations. Big one, obviously, repeat citations, which we talk about, and there'll a slide in a second that I'm going to go over. Repeats are now 156,259 for the max penalty, same amount for a willful. So these numbers obviously add up quickly if you get multiple repeats or multiple willfuls, and even now with a group of serious citations, at 15,625, you can get to some real penalties relatively quickly, and these numbers are going to go up again in 2024. This was also not a surprise to me based on what I'm seeing out in the field and very aggressive, very comprehensive inspections. That the number of $100,000 penalty actions set a record last year, and significantly blowing past prior years, right? And if you participated in our 2018 webinar, I'm sure you remember we talked about how surprised we were to see the number of $100,000 cases in the first year of the Trump administration, that it passed 200. If you've been paying attention, I think we've been saying all along we expected last year to be the highest, and OSHA certainly met that and exceeded it, going over 343 to be exact, right? And when you have $150,000 repeats and willful citations, it just takes one to get you over $100,000. So I would expect that number to be right in that same neighborhood, if not higher, in 2023 as well, when we're back here. Hopefully you all join us for our 2024 kickoff webinar. Moving on to the next slide, as I mentioned earlier, repeats continue to be an area of emphasis for OSHA, right? We all know, if you've joined us for past webinars, that we bang this drum repeatedly because it continues to be an area of emphasis for the agency. Willful citations, same penalty amount, right? But it's a higher threshold, requires a lot more evidence for OSHA to issue willful citations, right? If you've been in a willful case, they prepare a willful justification memo. A lot of work goes into it. It doesn't take a whole lot of work to issue a repeat citation, other than to find that the same or similar standard was violated with a hazard that is similar to what the prior hazard was. So repeats continue to increase each year, by and large. And as you can see from this chart, we've kind of cut out some of the year-by-year summary that we've used to show. But if you look at that significant and steady increase, right, going back to 2002, when it was only about 2.5% of all citations were issued as a repeat. Now OSHA's knocking on the door at 6%, and it's more than doubled. And I would expect with the current administration's priorities that we'll see a number over 6%. When this year's numbers come out, right? And historically, as many of you know, particularly if you've been in safety and health for a long period of time, that OSHA really used to just issue repeats if it was the same facility, and it would be coming out only if something else happened at that facility, and they'd only be looking back 3 years. And then during the Obama-Biden administration, and continuing now OSHA will cast a net that is nationwide in other federal locations. Last year we had and I'll also look back 5 years. I had a citation issued to a retailer for repeat citations for blocked electrical panels and exits, where one citation was in a Midwestern state, the repeat based off of a state in the Southwest. Or in the South, and it was 4.5 years earlier. So they went basically almost as far as they had to or could, both from a time standpoint as well as a distance standpoint, to find that prior violation on which they can issue a repeat. And I think the part that I'm seeing even more now is this proactive targeting philosophy. As I mentioned earlier, follow-up inspections. So I'm dealing with, we contested a repeat citation that was issued last year to an employer that there were no accidents, no injuries, nothing happened at that facility other than OSHA showing up to do a follow-up inspection, and that led to a new repeat violation. So the last slide I want to cover just briefly, and part of OSHA's proactive enforcement and targeting philosophy or approach is getting out and doing programmed inspections, meaning inspections that are issued or open based on your membership or your NAICS code, the industry in which you operate. Some of these are broad, right? So we talked last year about the heat illness emphasis program. That's a national emphasis program, pretty broad coverage on a number of industries, both indoor and outdoor heat illness. Others, also the amputations emphasis program, another national emphasis program that focuses on lockout, tagout, and guarding, very broad reach. I've had several clients recently that have been where OSHA has opened an amputations emphasis program. The one that I want to really focus on for everybody is, go on to, if you feel free to reach out to us or go onto OSHA's website, check the region that you are in and check to see if OSHA has opened or launched any new local or regional emphasis programs. There were a number that were launched in the last couple of years, and particularly right now, what I'm dealing with is a food manufacturing emphasis program. So employers in Wisconsin, Illinois, and Ohio that are subject to these inspections, very comprehensive, very focused on lockout, tagout, guarding, and sanitation. There's also a local emphasis program or regional emphasis program in Region 3 for warehousing, quite a few regional and local emphasis programs that deal with forklifts, grain handling, noise. So figure out which emphasis programs apply to your operations, and they have, you can pull the program, you can read it, and you can get a sense exactly of what OSHA is going to look for if they open an inspection of your operations based on one of those programs. And know also that if they show up to do an accident or a complaint inspection, they will likely try to expand it into one of those emphasis program inspections if you are covered. I've lots of inspections where a forklift drives by and they say, okay, now we're opening a forklift emphasis program because we see you have those. So do your research or reach out to us and we'll let you know. And if you have questions on what you need to do to prepare for those inspections, give us a call.
Great. Thanks, Aaron. I wanted to cover a couple of specific enforcement issues that I think are going to be very hot topics in 2023. And the first one, if you've followed our webinar series or our blog, or you have, or you know me at all, you've heard me talk about the severe violator enforcement program. This is a big pet peeve of mine. One of I think a really poorly implemented, poorly conceived enforcement program that OSHA has developed. And I'm not just taking another opportunity to swipe at it. OSHA actually made some significant changes to this program, announced in September of last year, that we're about to start seeing the results of here in 2023. If you don't know anything about the Severe Violator Enforcement Program, it is a program that OSHA uses to target its enforcement resources at particular employers that OSHA believes have demonstrated indifference to their OSHA Act obligations. And until September of this year, OSHA believed that you demonstrated indifference to those OSHA Act obligations by receiving citations in one of these four categories. One is any egregious enforcement action, which is an enforcement action in which OSHA has issued per instance citations. Instead of one violation for not wearing a hard hat, it is 10 willful violations for each of 10 employees who is not wearing a hard hat. And the context there is willful plus some aggravating characteristic. Any citation package in that category qualified you in. One or more willful or repeat citation related to a death or the hospitalization of 3 or more employees would qualify you into the program. 3 or more willful or repeat violations related to the process safety management standard for petroleum refineries and chemical manufacturers. But the big bucket, the one that qualified the most employers in, was this 2 or more willful or repeat violations or failure to abate notices. That's what the FTA acronym is there throughout, involving a high emphasis hazard. And the high emphasis hazards was a pretty discrete list. That is the entire list at the bottom of the slide. Those aren't examples. That is every category, every set of standards or hazard that OSHA characterized as high emphasis. So if you got 2 or more willful or repeats in a single enforcement action involving one of those sets of standards, you would qualify into the program. And that was about 70% of the employers that qualified that way. And about 75% of those were qualifying in because of repeat citations, not willful citations. And in a lot of ways, that has been my big pet peeve with this program, is that a repeat citation is not necessarily a sign of indifference. You know, Aaron talked about 4.5 years apart at facilities on 2 other ends of the country, at a company that has 5,000 locations. I think it's really unfair to say that that's an indifferent employer, but that is what was happening. A lot of employers were getting in that way without that aggravated intent, that aggravated knowledge, enhanced knowledge of what was required, and indifference to that a willful violation represents. They were doing it with repeat violations mostly, and in these small categories of high emphasis hazards. Well, the change that was announced in September was to do away with that high emphasis hazard element. So now it's still egregious actions will count, 1 or more willful or repeats related to a death or a catastrophe get you into the program. But now doesn't matter about PSM standard, doesn't matter about any of those other high emphasis hazards. If you get 2 or more high gravity, willful or repeat citations involving any hazard, any standard, you are qualifying into this program. And OSHA estimated when they made this announcement that it would be about a 3x increase, based looking back at old enforcement data, that about 3 times more employers would qualify into the program based on this new criteria. And so one of my big grievances with this program is that it did a pretty poor job of targeting the right, bad actors. I mean, the programming concept is a good idea. OSHA should use data. They should be smart about targeting their resources and target truly bad actors. I thought the program did a pretty poor job of identifying true bad actors before. Forget about that. It is going to be 100 times worse now, bringing in employers that have no business near a program called the Severe Violator Enforcement Program. But that's what we are already starting to see at the very end of 22, and we'll surely see in 2023. Why is it a big deal? You get into the Severe Violator Enforcement Program, there's pretty severe consequences, and it applies, unfortunately, the moment the citation is issued. You can negotiate your way out or litigate your way out, but you're dumped into the program just based on OSHA's allegations, and immediately start experiencing some real, I call extreme public shaming. OSHA puts out a press release for every severe violator case, brands the employer as a severe violator, includes ugly quotations from a OSHA official about the company. And then they have literally a bad actors list on their website. The severe violator log on OSHA's public website identifies the employer, the location where they qualified in, and other characteristics about the enforcement action. So real negative impacts to your reputation, public shaming, and then some other consequences, including mandatory follow-up inspections at the location that qualified you in. And now another change in September is potentially unlimited sister facility inspections, call it a follow-up inspection at a related company, a related location within the same corporate organization. So now you're seeing being characterized as a bad actor, and then seeing OSHA over and over and over again, with them walking in the door thinking of you as a bad actor, creating a really difficult gauntlet for those employers to run. Likewise, to resolve severe violator cases, OSHA insists on corporate-wide abatement and onerous settlement provisions that go beyond, abatement, beyond minimum regulatory compliance, like requiring third-party audits and things like that. And their thing is, look, you don't have to settle with us, but if you're going to settle an SVEP case, it's going to include these onerous type settlement terms. And then there's a bunch of other indirect consequences from qualifying in. We already talked about impact to reputation, certainly your ability to retain employees or recruit new employees. If a federal agency is declaring you a bad actor and a severe violator, puts challenges there. We've seen it impact your relationship with your banks, your insurance companies. We've seen unions use it for organizing campaigns or use it for leverage at the bargaining table. We've seen plaintiffs' attorneys use it as a way to target potential actions to bring. We've seen the media seize on this and run with it. We've seen competitors and others who would intend to do your business harm take advantage of this severe violator designation. So this is expected to ramp up in 2023 because of those changes. A few other enforcement issues that we think are really important to monitor in 2023 are here on this last slide I was going to talk about. One is, we heard from the director, from the Assistant Secretary of Labor for OSHA, the head of OSHA, at a speech that he gave recently, that the agency expects, just like they reformed the severe violator enforcement program, that they are also working on some reform to the egregious policy, the per instance policy that I mentioned in the context of the severe violator enforcement program. Right now, based on the 1990 policy that still dictates when OSHA can use these per instance citations, it's pretty narrow. It has to be a particular kind of standard that talks about individualized duties, like train each employee, provide personal protective equipment for each employee. The language of the standard dictates whether it's even possible to be cited on a per instance basis. And then OSHA needs to find willfulness and some aggravating, some aggravating factor to issue these per instance citations. And that's where Aaron was talking about, 4, 5, or 6 willful violations. Now, with OSHA's new penalty authority, is where you start to see these $1 million enforcement actions or near $1 million enforcement actions. So we don't know specifically, he wouldn't say what these reforms are, but I think we can look at what they just did to SVEP and say, well, that's a pretty good indicator that they're not going to reform this policy to make it harder or to make it less frequently used by OSHA. The whole point of this, use all the tools in the toolbox. And we keep saying that because that's what we're hearing from the leadership at the Department of Labor when they give speeches about how OSHA can sharpen its teeth. I think we can expect that these reforms will be done in a way to expand the use of per instance citations. And that's, something to look out for in 2023. We expect to see that soon. 2 other things that just got announced, one of them earlier this week, actually both of them within the last couple of weeks, is OSHA revisiting the concept of the worker walk-around representative policy. Back in 2013, during the Obama administration, OSHA issued an interpretation letter that said that, and the law provides, and there is a regulation that says employees may have an authorized representative. They may authorize a representative to go around with OSHA during an OSHA inspection as the employee's representative. OSHA issued this interpretation letter in 2013 to say that representative that employees may select can be a union representative, even if your workforce is not organized, even if there's no collective bargaining agreement covering that workplace and those employees are not part of a union, a non-union work site. Employees can designate a union representative, like a union organizer, to come in and participate with OSHA during this inspection. And that appeared to me and many others to run pretty contrary to the regulation itself, 1903.8C, that says the representative authorized by employees shall be an employee of the employer, except in very narrow circumstances. And those narrow circumstances are when OSHA determines that a third party who is not an employee of the employer is necessary for OSHA to be able to conduct an effective and thorough physical inspection. And the only examples that ever were done there were some sort of technical expert, an industrial hygienist to do monitoring for OSHA if they didn't have that technical expertise, or an interpreter to help if there were language discrepancies between, OSHA's ability to communicate with employees in an interview. And OSHA tried to say, well, that, reasonably necessary language in 1903.8C allows us to say, sure, let's bring in a union representative because that may be reasonably necessary. And that seems like a huge stretch. So some industry groups brought legal challenges to OSHA, saying that they were basically rewriting a regulation without rulemaking and in a way that was plainly contradicts the language of the regulation. It was arbitrary and capricious. OSHA maybe saw the writing on the wall, so they withdrew that letter. More likely, I think they withdrew it because by the time these legal challenges were heading somewhere, we had transitioned to the Trump administration, I believe, when they withdrew the rule or withdrew the interpretation. But now, just like a few days ago, OSHA revealed in its fall regulatory agenda, which was revealed deep into winter, that they have initiated a new rulemaking to revisit 1903.8C and to revisit this idea of who would be an appropriate worker walk-around representative. And it's pretty apparent that the purpose here is to try to, among perhaps other ways to expand that, but is to expand the regulation to allow for this union representation at non-union sites during OSHA inspections. So that's something to look out for on the rulemaking front. And it's actually proposed to be completed in 2023. That strikes me as very aggressive timeline by OSHA, but we'll certainly be tracking that and why we've included it here as an important issue to watch this year in particular. The last thing is OSHA in that same rulemaking agenda revealed another new rulemaking to clarify its procedures for the use of administrative subpoenas. And OSHA says, its current subpoena practice has resulted in a lot of time-consuming disputes between OSHA and employers about when a subpoena is appropriate, the appropriate scope of a subpoena, and how those subpoenas are executed and enforced, and how employers need to respond to a subpoena. I'm not sure I agree or follow the idea that there is some lack of clarity. I think OSHA's field operations manual lays it out pretty clearly, and federal law dictates this. This rule is not going to change federal law because these things are enforceable in the federal district courts, not by an administrative law judge. But nevertheless, OSHA is moving forward with this rulemaking, and this one they've even proposed to do with an interim final rule. So they're going to do something this year that will go into effect even as the rulemaking is proceeding. And the concept is to provide clarity to OSHA, to its field offices, for when and how to use subpoenas, and clarity for the regulated community for when they can expect to see them and how they will be implemented and how employers are expected to respond to them, and also to provide transparency and some uniformity in the subpoena practice. So those are some pretty significant enforcement issues that we'll be tracking in 2023. And now I'm going to hand it over to my partner, Kate McMahon, to talk about the other side of the OSHA house, promulgating new rules. And I talked about two of them already, but she's going to talk about more of the meaty, substantive health and safety rulemakings that OSHA has going on now. Take it away.
Thank you, Eric. And hello, everyone. Like Eric and Aaron described on the enforcement side, what we're seeing this year, we're sort of sizing up year 2023 to be one of the most active rulemaking years in OSHA's, possibly in OSHA's history, certainly in recent years. We're seeing a lot of activity already right out of the box in January, highly unusual. Eric already described some of that. I want to just share with you that the backdrop here, remember that the Department of Labor and OSHA are both led by former officials of the labor movement itself. So It's certainly not surprising and really expected that this administration, that these folks that are former union officials and were part of the labor movement for decades would want to leave their mark on worker health and safety before this term ends. There's no guarantee ever for a second term, so they don't know what's going to happen. None of us know what's going to happen in the next presidential election. So we expect that they have now gotten themselves geared up. They spent the first year sort of getting organized. Year 2 was pretty active. Year 3 is going to be very active. And for those of you who work in the rulemaking space like I do, we know even in this administration, Democrats and Republicans alike, by summer of the presidential year, so by July, August of 2024, next year, the rulemaking apparatus essentially is probably going to shut down, right? So they basically have about 15 years to really make a mark and move the rules forward that they want to, they'd like to promulgate. We'll see if they get there with some of these more controversial rules, but we expect it to be very active. This regulatory agenda, as many of you on the phone know, OSHA, all federal agencies issue a regulatory agenda that is supposed to be sort of a roadmap of where they are going and what they are working on. This is OSHA's regulatory agenda for the fall. They do this twice a year. It came out in December, and it's a clue to where OSHA's priorities are. Typically, and certainly probably more often in Republican administrations, you see, there's always a lot of stuff on OSHA's rulemaking agenda. The difference between what we saw in the Trump administration and we see typically in Republican administrations and this one is these rules sit on the regulatory agenda forever. And if you go on this website, you can click on each of these rules and see where they are, their status, what they're expected, and there'll be a date of the next activity. What typically happens is the agency just continually updates that date. They move very slowly. We know it takes on average about 15 years for OSHA to promulgate, historically anyway, for them to promulgate a significant rule, certainly any rules in the chemical space, and certainly over 5 to 8 years on pretty much any rule. So they just continually move the clock back. We're actually seeing real action that is not moving the clock back, but moving the clock forward on some of these rules. We've got 5 in the pre-rule stage, 15 active proposed rules, and then they're finishing up with 6, which I'm sure all be finalized. We don't have time today to talk about really any of these rules in detail, but we wanted to at least highlight a couple of the more impactful and controversial. And we're going to spend the next little while talking about those, but also know that we do webinars, as hopefully all of you know on the screen there. We do these webinars monthly. And in addition to our sort of monthly webinar series, we do specialized webinars where enough of our clients or people reach out and ask for information on things. So we're going to be talking about a lot of these rules over the course of the year, and we already have a number of these scheduled. But let me at least run through the top 10. This is Biden administration, Secretary Walsh, Doug Parker's top 10 list right now on the rulemaking side. Eric's already talked about COVID-19. We really are on the precipice of a permanent rule for healthcare. Although, FYI, just for those of you interested in that space, OIRA is still taking meetings on the healthcare rule. So it isn't imminent, meaning like tomorrow. There's still meetings, but it is, as Eric said, we think quite imminent, around the corner. That's COVID. The permanent infectious disease rule for healthcare. Eric also mentioned that. All I want to say there is that rulemaking began in the early to mid 2000s. The Directorate of Standards had moved forward and was advancing a rule, and then it stalled by 2014. I think they had a SVEP panel that was called, but didn't actually put together a report, although I can't quite remember. But in any case, they had moved the ball forward on the infectious disease standard. In fact, some of the things we saw in the COVID rule came out of that. And we expect, because COVID is so controversial, at least outside the healthcare space, we expect rather that what they've done is pivot. They're taking now some of the information that they gathered, the tools that they think were important for managing COVID, and those are going to be built into the permanent infectious disease standard. So we'll be tracking that and monitoring that. We're going to talk for a couple of minutes. My partner, Dan Deacon, my new partner, Dan Deacon, is going to talk about the e-record keeping rule. I'm going to spend a couple of minutes on heat illness, a very, very top key priority. In fact, if I had to name one rule that I feel this administration wants to advance as far as it possibly can in this term, it would be the heat illness rule. They're doing an update on HAZCOM. That generally is, most of it is not controversial. They're basically sort of moving it to align with the global harmonization system, which is a continually updated standard that applies internationally. Ironically, because OSHA typically, even in its best days, does move slower than GHS, this update of HAZCOM will bring it up to Rev 3 of GHS, which was issued in 2009. GHS is now on Rev 8. So even when we get this rule, this HAZCOM rule finalized, it will be behind where GHS is. So this is really sort of a continual iteration of the HAZCOM standard. It will be updated. For those of you who deal with hazardous chemicals in your workplace, it's our recommendation that you are familiar not only with HAZCOM, but with GHS, because that's where OSHA will ultimately go. It just takes them longer to get there. PSM reform, process safety management, and RMP, that's EPA's sort of equivalent parallel standard. My partner Micah is going to talk for a couple of minutes about that. Workplace violence in healthcare social work. This is a rule that the the Obama administration was really pressured. There were lawsuits brought to move forward on establishing a rule, an actual standard for workplace violence, likely limited to healthcare and social work. That's where the data shows there are most violent incidents that occur. This administration has now put that back into high gear. They just reached out to the Small Business Administration within the last couple of weeks and notified them that they would like to convene a SVEP panel. That's a critical stage in the rulemaking process. So we expect to see a lot of activity at the Small Business Administration and at OSHA on advancing this workplace violence rule. Again, it's right now, and I expect will remain limited to healthcare and social work. But if you are on this call and you're in that space, check in with us about what we expect to see in that rule. And also whether you have the ability to become a small entity representative. In the SVEP process, the SBA would identifies small entity representatives. Of course, there are standards around, what size is small enough to meet that qualifier. But if you are, or you can work with other small entities, you could have a voice at the table in the SVEP process, which, as I said, is a critical stage in the rulemaking process. And the information that is collected in the SVEP process gets funneled in a panel report back to OSHA and can have an impact on the direction the rule goes. So that's active right now. Number 8, emergency response. There's nothing particularly controversial that I'm aware of about the emergency response standard. It's essentially trying to bring this current standard up to speed with the technology on response activities and PPE that are used now in emergency response. So it's basically an update of the existing rule focused on PPE. The update to the lead standard, I'm going to spend a minute right before I turn this over to my colleagues at the end of our discussion about rulemaking on the lead standard and what's happening there. And then the worker walk around representative issue that Eric already mentioned. It's a key issue that we're tracking carefully. Okay, so why don't I, with that, we're going to talk, as I said, about just a couple of the more impactful and probably controversial rules. And I'm going to ask Dan Deacon to talk about the e-record keeping rule. Dan?
Thanks, Kate. And hello, everyone. This is Dan Deacon. I'm going to go over the e-record keeping rule. This dates back to nearly 7 years ago when it was promulgated under the Obama administration. And it seems like every couple of years, this rule is revisited. There's either active litigation, the rule being rolled back, and we're currently under a proposed rule that's being considered. And we have an update for you on that as well. But just a quick reminder, we're going to go over this rule in 2 slides, really, and we could do an entire presentation on it. So this is just going to be very high level. But back in May of 2016, the Obama administration finalized this rule that required workplaces with 250 or more workers to annually submit their 300 logs, 301 incident reports, and 308 summaries. And the second piece to the rule was workers or workplaces with 20 or more employees in high hazard industries were going to be required to submit 300A annual summary data by a March 2nd deadline every year. OSHA was going to scrub employee identifying information, but all of that data was going to be made available publicly for anyone to search, and it currently is today. And as you all know, this information is being collected for enforcement purposes. They use this data to target certain establishments, and it is, I think we're on the second iteration of OSHA's site-specific targeting enforcement program. Currently, they're using data collected between fiscal years 2017 and 2019 to target those high-rate establishments, but there's also non-responders that are targeted, some low-rate establishments. Really, if you are subject to the rule, if you are a covered establishment, there is a chance that you end up on one of those SST lists that the area office develops and targets certain workplaces. So moving forward, 3 years later, in January 2019, the Trump administration issued an amended rule eliminating the requirement for large establishments to submit 300 and 301 level data. And really, this was the status quo. It was really formalizing that rule because even though there was a requirement as promulgated in 2016 for those larger establishments of 250 or more employees present to submit the 300, 301, and 308 data, it never went into effect. It was delayed. The injury tracking application, the portal, the electronic portal where data submitted wasn't set up to handle that information. So really that January 2019 rollback of the rule was just formalizing the status quo and what it had been since the rule was actually promulgated in 2016. So here we are today, March, or back in March of 2022, OSHA issued a proposed rule significantly expanding the e-record keeping requirements. And in the interim, between the Trump administration rollback and that March 2022 proposed rule, there had been a series of litigation brought on by petitioners challenging that rollback. But in March, the proposed rule issued by the Biden administration was significantly expanding the number of covered establishments that would be submitting data, as well as the actual data collected, right? It was more akin to what was initially promulgated back in 2016 by the Obama administration. So there's really three key proposed changes that you see on the screen here. One, to maintain the requirement for establishments with 20 employees in high hazard industries to submit 300A data. However, they are going to review and revisit and update Appendix A, so that list of covered establishments by NAICS code. The second requirement and change is it eliminates that requirement for all places with 250 or more employees to submit 300A data. And it's going to replace that requirement with a new requirement for establishments with 100 or more employees in a separate set of high hazard industries. And this is going to be a new appendix, Appendix B. And those covered establishments are going to submit 300, 301, and 300A data. As of just a couple weeks ago, OSHA did signal in the regulatory agenda, this proposed rule was supposed to be finalized by March of 2023. It does not appear that that is going to happen. In the litigation that is ongoing in the DC Circuit Court challenging the Trump rollback of the rule, that case was held in abeyance, and the petitioners just filed a motion to reopen the case because OSHA has signaled that it will not be finalized. The proposed rule will not be finalized by March 2023. Rather, we're looking at June 2023. So we do anticipate this being finalized sometime within the next 6 months, and the data submission requirement may be changing coming up by the March 2nd, 2024 deadline. So with that, I'll turn it over to Kate, and she'll cover the heat and illness rulemaking.
All right, I know we have only about 10 or 15 minutes left, so we're going to be quick here, but let me just, because I mentioned that it's at least my view that this is the top priority of the administration in terms of getting a rule out, at least in proposed form in this term, if at all humanly possible at OSHA. And I'm not sure that is the case, but they're working, I think, on that. Would you go to the next slide, Eric? Sorry. This is sort of an outline. Doesn't really matter about sort of what's happened so far, but just very briefly, in 2021, fall of 2021, OSHA issued an advance notice of proposed rulemaking. That advance notice of proposed rulemaking had like 150 or so questions that it was asking stakeholders and the regulated community to comment on. Those over 1,000 commenters submitted comments, and those were including us, on behalf of a broad coalition of employers who are will be affected by a heat standard. Those were submitted by January. So all of 2022, OSHA has been reviewing the comments, synthesizing them, figuring out what's important, what's not, what's most controversial, what's not. Also, the National Advisory Committee, the NACOSH committee that coordinates with OSHA on occupational safety and health issues, established a work group on heat illness. And that work group is essentially grouped into two pieces. One is working on compliance assistance tools for heat exposure. And the other one is working to develop recommendations to go to OSHA on the rule and what it should look like. Just in January, a month ago, the NACOSH work group on compliance assistance issued its report and reported back to the agency on, what some recommendations on tools, on compliance assistance. That's actually pretty helpful information that NACOSH has developed. We're very interested to see what we're going to see in terms of compliance recommendations that would be fed into the rule. And we expect to see those in 2023, first or second quarter. Those will go back to OSHA, but they're public, so we can get a handle, we can get a look at what we, what is being recommended to OSHA. Next slide. Just on the substance of the rule itself, oops, sorry, I mean backwards one. Yeah, thanks. On the substance of the rule itself, in the ANPRM is often a clue to where OSHA would like to go. Now, they sometimes feel like they've got to pull back when they get a gazillion comments that tell them you can't do this. So the proposed rule looks a little milder most often from an ANPRM. But what we saw, we don't have the proposed rule yet. What we know about the ANPRM is it was a pretty robust and comprehensive rule. It, of course, included a requirement for a written heat program that every employer, and by the way, this covers both indoor heat as well as outdoor heat. We knew it would cover outdoor heat, any heat rule would. We didn't know it was going to cover indoor heat. We don't know whether the proposal will, but that's at least what was in the ANPRM. In addition to a written program, which, is not particularly controversial because I think all OSHA programs require a written program, there's engineering controls, administrative controls, potable water to be supplied so that it's readily accessible to workers, acclimatization requirements, that there could be some pretty rigid acclimatization requirements that are in the rule. That's a key issue for employers, I think. Robust training, possibly some requirements to do physiological or medical exposure monitoring to determine who might be at most risk when to a particular heat exposure that the employee might experience. And of course, emergency response plans to deal with a situation where you do have a heat emergency. So that's sort of the outside boundaries of what would be in a rule. And we're following this one very, very carefully. We're involved on behalf of this coalition in all the activities. We tend and speak at all the NACOSH meetings. And we'd love to hear from any of you out there who have, whether you're in the coalition or not, have concerns or interests in the heat rule, so that we can help fashion our involvement. We're working closely with OSHA, I hope. Lead standard, 1 minute on this. The rule that OSHA is planning to issue is not, in my view, particularly controversial. It is designed to lower the standard at which the amount of the amount of lead in blood would trigger medical surveillance or medical removal from the workplace and lower the level at which a worker could come back to work. I say it's not controversial because these levels were set in the late 70s. The lead standard was one of OSHA's first comprehensive chemical standards. And it is, as are many of OSHA standards, woefully out of date and inadequate to protect workers. So OSHA is thinking about lowering the level at which workers can, be in the workplace and go back to work based on their level of lead in blood. What is controversial, and OSHA seems to be toying with this, is as part of this rulemaking, to broaden it significantly, potentially, to lower the PEL. The PEL right now for 8-hour time weighted average, it's 50 micrograms per meter cubed, and the action level is 30 micrograms per meter cubed. OSHA's at least considering engaging on the PEL and action level, and that depending on where they go with it would be highly controversial. There are certain states that have already taken action in this area, and OSHA's looking to what the states have done. So keep a careful and watchful eye on this, and we certainly are too if you have lead in the workplace at all. All right, let me now turn it over to Lindsay, who is going to talk about the whistleblower activities that OSHA is engaged in. Oh, no, let me not do that. Let me turn it over to Micah on PSM. Sorry about that, Micah. You're muted. Micah, you're muted.
Thank you. Sorry about that. It was the double mute that got me. Okay, I'll give a quick overview of where we stand on PSM and then hand it over to Lindsay. So here's a quick history of where things stand. As Kate was mentioning, a lot of rulemaking efforts that may have started with the Obama administration didn't make it all the way across the line. We're seeing some of those come back. Here's what we saw in the not too distant past for the PSM rule. Back in 2013, there was a major event in West Texas that resulted in an executive order from President Obama that directed EPA and OSHA to move forward with reforming some of the chemical safety rules, PSM for OSHA, RMP for EPA. OSHA opened up a request, or they sent out a request for information, collected information back in 2014, moved ahead with the SVEP process in 2015-16. Did not actually get a new PSM rule proposed, finalized, anything like that. We never actually got proposed regulatory text. And so with the change in administrations in 2017, we saw OSHA and EPA split. EPA was able to get their RMP amendments issued before the end of the Obama administration. So while OSHA sat back and tabled the PSM rulemaking, moved it to the long-term regulatory agenda, EPA had the RMP amendments out, but EPA under the Trump administration delayed those amendments, ultimately rescinded many of the provisions in the RMP amendments before the end of the Trump administration. Moving to the next slide, then we arrive with the Biden administration, and we see where the Biden administration went ahead and picked up the baton and started things moving forward again with the PSM rulemaking. It took a little while. We know it wasn't as high a priority, let's say, as COVID rulemaking or maybe even as heat illness. But we did see back in 2022, maybe mid-year, that OSHA indicated clearly their intent to move forward with rulemaking. They issued a notice for a stakeholder meeting, reopened comments, and allowed folks to give some additional information and comments on that. With that said, it's clear that they've reopened the rulemaking, but we haven't seen a whole lot of movement yet. Right? There's no new text. The issues that they requested information on are very similar to those that were presented back in 2014. The new issues mostly track the issues flagged in EPA's RMP rulemaking, And so we still don't know exactly where they're going. We just know that they're going. On the next couple of slides, we have some examples of things that are potential changes we know are on OSHA's radar. We won't talk through each of them, but if you follow the rulemaking, you'll see that many of these are familiar, either from the previous rulemaking or from litigation in the recent years. For example, adding oil and gas well drilling and servicing, taking enforcement over for oil and gas production facilities. Those are things that we've seen popping up on the radar, either in the previous rulemaking or in enforcement. Moving into explosives and blasting, so the PSM can cover those activities. That's something we've known is out there. Here on the bottom of the slide, there are some of the newer issues, and several of these track with key court cases. You'll know that defining the limits of a PSM covered process tracks with the issues that were litigated in the Wynnewood refining case, the definition of RAGGAP and of critical equipment. That tracks some of the issues that came up in the BP Husky cases and the Delic cases back in the 20-teens. And so those are some major issues that we know have been on OSHA's mind, and we think will show up here. On the next slide, I think we have a couple of additional changes. These are some of the more specific PSM elements that OSHA has signaled that they may want to make changes to. Some highlights here are for process safety information that's covered in paragraph D, making an explicit requirement that employers are required to continuously update the process safety information. Previously, it was understood from the structure of the rule that while it needed to be accurate, the actual requirement to update didn't occur until right before every PHA. On the PHA front, there's these requirements, the requirement for safer technology and alternatives analysis that mirrors something that we've seen EPA grappling with over the last 5 years in their rulemaking. So that tracks there. The requirement to consider natural disasters and extreme temperatures, that matches with EPA proposed requirements, and then also some of the weather events that we've seen over the last few years. I'll skip over most of the rest of them. I think some of the newer or more interesting requirements here are the last two. An explicit requirement for an employer to have a written procedure to cover every element. That's a new thing. We think that most employers have effectively done this in the past, but in the absence of a clear requirement, very detailed in how you're supposed to do that, there's probably a lot of divergence among companies on how they do that. So where OSHA goes with this requirement could be particularly interesting and could cause a challenge for some employers. And then, of course, with that requiring a written procedure, the proposal that there would be a periodic review and a revision for that. It's similar to what you see in a compliance audit provision, but to apply it to some of the documents, particularly when you're talking about the high-level program documents. It's a new requirement, and we're not exactly sure how that would work. And so those are some of the things that we're watching most closely. We think that OSHA will, intends to move forward with this. I don't think it's as high on their priority list as heat illness is. So, it's an open question whether we'll see a proposed rule before the administration. If I had to bet, I think they'll take another step before we get to the end of 2024, but we'll wait and see. So with that, I'll hand it over to Lindsay to talk about Whistleblower.
All right, thanks, Micah. So to close us out today, we just wanted to review some basic things that we've seen related to whistleblower retaliation cases and what we think we'll see going forward. So over the past few years, we've definitely seen an emphasis from the Department of Labor and OSHA specifically on investigation of retaliation and whistleblower cases. As some of you may already know, OSHA is actually charged with investigating retaliation complaints for approximately 25 different laws. So there's Section 11C of the Occupational Safety and Health Act, which is OSHA's whistleblower protection provision. But OSHA is also charged with investigating the whistleblower anti-retaliation provisions and a lot of other laws. So this has been a big job for OSHA, and we have in the past certainly seen some extensive time taken with investigations because there are so many cases on the investigators' dockets. But this has definitely been something that OSHA is trying to address. And one of the ways that they have done that is to hire additional whistleblower investigations so that they are able to, really dig into these complaints that are filed, particularly the 11C complaints, which make up a bulk of their docket more effectively, and actually hired approximately 93 new whistleblower investigators back, I think, around the beginning of last year. So we've definitely seen an increase in the number of whistleblower investigations over the past couple of years, based on the timing of everything, as well as, some of the experiences that we had during the COVID-19 pandemic. There was definitely an increase in that during that time period, and we'll see that a little bit on the next slide. But this has not only been a focus for OSHA from an experience perspective, and actually, being involved, our firm being involved in several whistleblower investigations over the past few years, but the Department of Labor and OSHA have explicitly expressed this as well, that this is a focus for them, that they have been spending time analyzing the whistleblower program, figuring out how to more effectively implement the whistleblower program. And actually in November of 2021, the Department of Labor, the National Labor Relations Board, and the Equal Employment Opportunity Commission announced a joint initiative to raise awareness about retaliation issues, and to really ensure that both workers and employers are aware of the applicable laws and the restrictions and remedies that they have. And then, interestingly, from the OSHA perspective, and one that has actually been in place for a more extended period of time, is there are agreements between the Occupational Safety and Health Administration and the National Labor Relations Board related to retaliations that will be information sharing between the two agencies to the extent that one believes, based on the information they've collected, that an employee could have a claim or complaint with OSHA in the case of the NLRB, or with the NLRB in the case of OSHA. And then there's also a similar agreement between the Wage and Hour Division and the Occupational Safety and Health Administration to, again, have that information sharing as necessary to address some of these related concerns. Next slide. So this is what I was referring to on the previous slide, shows some of the statistics surrounding the number of complaints that have been filed with OSHA over the last 5 years. You'll notice that there was a significant spike in fiscal year 2020, which would include much of the height of the COVID-19 pandemic. You have over 2,500 11C complaints. So that's not even the total complaints. There were 2,539 11C complaints that were filed with OSHA for investigation based on retaliation allegations. And then we did see a drop in that a little bit in fiscal year 2021. But then, interestingly, over the past year, there has been a significant increase, and this is, the first time since that really large increase back in fiscal year 2020 that we've seen the numbers rise back up above 2,000. So again, this just sort of reflects what we've already been talking about, that whistleblower cases are definitely an emphasis and a focus for OSHA right now. And we're seeing them a lot in the form of 11C whistleblower complaints. And these statistics are all federal OSHA, but we have also seen an increase in the whistleblower complaints that have been filed, or anti-retaliation complaints that have been filed at the state level as well. And there are individual state agencies that are also actively investigating these types of complaints. Next slide. So then finally, like I had said in the beginning, the whistleblower program has been a focus for OSHA, and they have been analyzing how to make it more effective, how to align some of the different provisions more, some of the different investigation steps that have to be taken. And so one of the ways that OSHA did that last year was to update its whistleblower investigations manual back in April 2022. And that was significant because that was sort of the first complete overhaul that OSHA had done of its whistleblower investigations manual since 2011. So the prior revision was actually 2016, but a significant change to the manual had not been made since 2011. And some of the things that the 2022 manual did was to just try to clarify and streamline certain procedures, make them a little bit more accessible to both employers and employees to better understand this process. And then they did remove some of the statute-specific information and actually include that in individual desk aids that can be accessed through the OSHA website for reference as to those specific types of complaints. And then the other thing that they're doing is they are undergoing a rulemaking effort to address some of the procedures that are used for whistleblower investigations. They intend to promulgate an interim final rule, and the projected date for that is currently February 2023. As multiple people have talked about, that doesn't necessarily mean that's when it's going to come out, but that is the current projected date in the regulatory agenda. And this rulemaking effort is really just, again, to sort of create procedural consistency and greater accessibility to the procedures that are used for whistleblower investigations for both employers and employees. So with that, I think we are ready to close out the webinar.
Thanks, Lindsay. Thanks to everybody on the team and everybody who stuck around. We continue to try to work to get our hour-long webinars done in less than an hour and a half. And we're confident we'll get there this year. The January one is always our longest because we're setting up so many important discussions for the rest of the year. And this is the schedule for the rest of the year. I hope you all can join us for each of these programs. I encourage everybody to register for all of them, even if you think you can't be there the day of. If you're registered, you get a follow-up note with our recordings and copies of the slides. So I encourage everybody to get in there and participate and reach out to us and let us know if there's topics you think we should be covering and we haven't over the course of the last few years. We're always looking for good ideas for the programs. And also, if you have workplaces covered by the Mine Safety and Health Administration, we have just announced, I think this is brand new announcement about our 2023 MSHA webinar series. Here's the topics. The first event is in the middle of February, and you can see everything else that is going on. Great programs there if you have workplaces covered by that agency. And then, of course, there's our blogs. Check those out. These are growing in number. We've got, the OSHA Defense Report, the Employer Defense Report, and then a couple of even more specialized platforms as well for Cal OSHA specific content and for mine safety and health content as well. Check those out. And to brag a little bit, last year, if you all didn't hear or see, our firm was honored as one of only 3 law firms recognized as Band 1 OSHA in the OSHA practice. That was the first year that the Chamber's organization ranked the occupational safety and health law category. So we have been Band 1 every year that this ranking has existed. And you'll hear an announcement about that if we maintain that ranking. If not, it's a total sham and don't pay any attention to it. But we're excited for feedback from our clients who no doubt contributed to that recognition last year. And we thank you for that. And I think we've gone for such a long time. What we're going to do is collect the questions that we see in the chat and reach out to you all and address some of those by email. And if there's other questions that have been popping around in your head and you want to check in with us, don't hesitate to send a note to any of us on this call, and we will follow up with you. And we appreciate everybody's time, and we look forward to spending more time with you over the course of the year. So thanks, everybody.